What is wrong with you? This case is horrible. This is a life case, honestly.
Is by penetrating the anus with his finger, that did not happen.
Didn't do it to like hurt my daughter. The thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times.
Blaming a 6-year-old? Are you saying that you were molesting her, and as you were molesting her in such a way because you didn't want her to hurt her, grabbed her, and you're making it seem like your finger just accidentally penetrated the anus? So, State, you want to explain to me why the court should follow this 15 years?
Recognition therapy course.
Somebody don't want to have sex with you, and they tell you no, you don't have sex with them. Because then, guess what? It's not consensual, it's rape. But here we call it sexual assault. So what is up with this lipstick tattoo on your neck? You know what I'm saying? If your attorney does not want you or recommend you speaking to me, there's probably a good reason for that. And I'm sure she may have told you that. Knowing that, if you still wish to speak to me, you may speak to me.
Ma'am, I would.
Yes.
I would like to speak to you because I know that my attorney has gone to law school just like you have.
No. No, just go. Come on. It's calling 2023 CR 0543, State of Texas versus Wilbert Villamil. State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
No, Your Honor.
Do you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
You're a U.S. citizen?
No.
Did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of entering a plea in this case as it relates to your immigration status?
Yes, Your Honor.
All right. According to the plea, you're pleading on count 3. Punishment is to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's Chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this
Exactly.
complainant his relative or not?
Yes.
Okay.
Yes.
To the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept
Your
this
Honor,
agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to re-traumatize the child by bringing her in and talking to her about this case yet.
this case is horrible. And I mean, I know he says he's pleading to a one-time penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal issues
Yeah.
with that. So
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
that's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's
And you got turned on.
no, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean? Like,
So you blaming a 6-year-old?
I'm not blaming my 6-year-old.
Your Honor, my client was sexually abused when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously it's not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will.
So he's being released after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that to do that. We have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which.
And what country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point. What were you thinking?
Yeah, I can just say sorry, but like the only thing I can tell you is that I I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mm-hmm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in and, as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up, and he's going to lose his freedom for up to 15 years, and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 85% of their time, and so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you and now that he has done it. And what
He pled no contest.
He pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah. So, I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
Sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried. I'm begging and telling you, please. I'm telling you, please. I'm not trying to force my hand in her vagina or in her ass. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't. I don't know how to explain.
No, so the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated the anus.
The thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times. dropping her pants, to, like literally, like it's not like I'm telling you like my actions were right.
I know, I'm just trying to figure out where you are mentally and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time, he told police officers that he had put his finger inside of her anus.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has sexual deviancy, and it's obvious. But all of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right. So this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother, and the benefit of the child was to get this done, have no right to appeal, so the child could move on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right. If you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
Or for State of Texas versus Eric Della Riva, can I have parties announced for the record for the state?
Michelle Hayden for the state.
Defense?
Austin Hagee for defense.
And are you Della Riva?
Yes, sir.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor. I have.
Court will find that the state is in compliance with discovery. Mr. Della Riva, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it?
Yes.
Next, I'm showing you the true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we have one oral amendment that we've agreed to with the state on count 2. We're taking.
We're going to get to that. So do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on count 2, waiving counts 1 and 3. And there's some language at the end of count 2 that says end violence. And we've agreed to waive that portion of the indictment. We would make the oral amendment to strike through that language. And it's actually, I believe, in the stipulations marked through.
All right. So in count 2, you all are, well, first, defense, do you have any objections to the waiver of count 1 and count 3?
No, Your Honor.
All right. And then with regards to count 2, the language that is being removed are the words "and violence." Is that correct?
Yes, Your Honor, at the very end.
All right. Any objections?
No, Your Honor.
All right. Mr. Della Riva, do you understand that to be a substantive change to the indictment?
Yes.
I'm sorry?
Yes.
All right. Do you have any objection to proceeding with that substantive change? I'm sorry?
No.
All right. And defense, are you waiving your 10 days?
Yes, Your Honor.
All right, Mr. Della Riva, I'm going to show you what's entitled Court Admonishments, the defendant's waivers, and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate
Yes.
places? Did you understand you're charged with sexual assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court, excuse me, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Del Riva, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
All right, off the record for a moment. Excuse me. I think the cause number 2022 CR 0065. That's Balboa.
Oh.
All right, we're back on the record. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, the state is proceeding on count 2. There's a $1,000 fine. State recommends deferred adjudication, Chapter 62 compliance, MRT, UAs, and no contact with the complainant. Did you understand that to be the plea bargaining agreement?
Yes.
Defense, is that the plea bargaining agreement?
Yes, Your Honor.
State, is that the plea bargaining agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places?
Yes.
Did you understand by signing that you were waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you what's outside the agreement. The state is recommending that your deferred adjudication be for a term of 7 years. There'll be a TAP evaluation, 80 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to count 2, as amended, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence.
State offer states Exhibit 1, its attachments and evidence.
Any objections?
No objections.
Mr. Del Riva, I'm showing you what's entitled waiver and consent for stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding you guilty if you apply for deferred adjudication. Now proceeding with sentencing.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Mr. De La Riva currently is employed. He has no substance abuse problems. He does take all this very seriously. During his brief time in custody, he got to experience how serious the justice system is, and I think he will be performing very well in deferred adjudication. He has no other criminal history whatsoever, and he does take all the charges against him seriously in this situation.
All right, if you're drug tested today, what are the results going to be?
I'll pass it.
All right, have you ever used any controlled substances?
Yes.
What?
To marijuana.
When's the last time you used marijuana?
Like 2016.
All right, what do you do for a living?
I worked for DoorDash, but I recently got let off for DoorDash.
I'm sorry?
I work for DoorDash. I used to work for DoorDash, but he let me off of DoorDash because of what was going on.
All right, so again, what do you do for a living? Because you're
Right
not,
now, I'm going to work with my uncle. He works for like cuts grass and stuff like that. Self-employment, basically.
okay. All right, they want you to do the MRT course. Is this to tell people don't sexually abuse people? Do we need
Yes.
to be told that?
Yes, Your Honor, it's the moral recognition therapy course.
Somebody don't want to have sex with you and they tell you no, you don't have sex with them. Because then guess what? It's not consensual, it's rape. but here we call it sexual assault. Do you understand that?
Yes.
Are you still meeting people on gaming?
No, I don't have a system anymore.
All right, then you know you can't have a system anymore. You understand that?
Yes.
And here's a hint for everybody. Don't go across country to meet somebody because you met them while playing PlayStation or whatever gaming system is out there, because you really don't know that person. You only know their avatar and not who they are. Right?
Yes.
Do you have any children?
No.
All right, court will sentence you to 7 years deferred adjudication. There's $1,000 fine, probated. Chapter 62 compliance. He used to be on the sex offender caseload. No contact with the complainant. And probation, that's listed in the indictment. There's 80 hours of community service restitution. Probation, I understand that there's no place for registered sex offenders to do community service hours. So the court will waive the 80 hours of community service restitution. If you provide proof of the COVID vaccination, the court is not requiring you to get it, but if you do, then those hours will be waived. I'm going to want a TAP evaluation plus follow recommendations. There's going to be regular reporting by Zoom, well, not by Zoom, in person. Field visits 2 times per month, random. And I'm sure the sex offender caseload probably does it periodically. Proof of employment. There's to be no employment as a home health care provider, no employment as with minors, and there's to be no employment where he is going inside people's homes. So yard work, that's fine, but you cannot do any employment going into people's homes unless you provide proof that that person has been informed or your company has been informed, and you provide that proof to probation. You understand?
Yes.
Is there anything else that he needs probation?
Your Honor, you said proof of employment within how many days?
Within 30 days.
And your analysis?
Yes, we'll do random UAs. All right, is there anything else he needs?
No, Your Honor.
All right, Mr. Delariva, is there? Yes.
He does currently reside in Houston, Texas, so he will be getting transferred to Houston, Texas.
Okay. Transfer, what county is that?
Harris.
Okay, we'll do a transfer to Harris County. However, you're not transferred to Harris County until probation in their county lets you know your probation has been transferred. Do you understand?
Okay.
All right. Mr. Delariva, is there anything else you need from the court in order to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
I'm sorry?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you. We're off the record. So what is up with this lipstick tattoo on your neck?
Huh? Oh, it was when I was like 16. I got it.
All right, is that anyone's lips in particular?
It's just something
Just
I
general?
wanted to get.
Okay.
Yeah.
All right, good luck to you.
Dennis Johnson.
All right, why can't you do right?
Your Honor, I just made some mistakes,
No, you made some choices.
some bad choices. Just
All right, court is calling 2024 CR 3849. Just one moment. And probation has to say longer.
Okay.
Yeah.
You're fine? Okay, we'll proceed.
You sure?
Yes.
Okay.
All right, court is calling 2024 CR 3849 State versus Dennis Johnson. Can I have parties announced for the record for the state? Defense? And are you Dennis Johnson?
Yes, ma'am.
All right, you entered a plea on August 27th of no contest and a true to the enhancement paragraph. And we are now back for sentencing. And according to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application.
That's great.
All right. Did you review the TAP evaluation and the PSI report?
Yes, ma'am.
Any objections?
No objection.
All right, defense, you may proceed.
Judge, the PSI seems to be very thorough. I know, of course, we had an opportunity to look at. There was mention in the PSI that my client is actually taking college courses. And we just wanted to supplement that with the courses and the thing that he done. The first page has to do with the student loans and that pertains.
Okay.
But the rest has to do with the grades. He's taking courses in business, and he indicated even in PSI that he wanted to start his own company, a trucking company. So he thought it was probably prudent to go to school. He said he's halfway through with his associates. Where he gets his associates, and then he's going to decide whether he'll go further or use his associates to start his trucking business.
All right, so let's get to the crux of the situation. Why can't you do right? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Dennis Johnson.
All right, why can't you do right?
Your Honor, I just made some mistakes.
No, you made some choices.
Some bad choices. Yes, ma'am.
So why can't you make good choices?
Your Honor, I have been making good choices since I got out. I drove trucks for 4.5, 5 years. I enrolled in college while I was on the road. And then when I got back, I just continued with college from being on the road.
So my thing is like, why does it take people picking up a case to start doing right? And I will tell you, I was a defense attorney, and I would always have these conversations with my clients. I always say, why must you be looking at prison time for you to do right? And I'm just trying to get into your mind to figure out why. Because obviously you're in college, so that means that you're intelligent.
Yes,
And
ma'am.
some people who go to college, maybe not, but it appears to me that you are very intelligent. I've seen some people who are going to college and they just breeze through. They don't have a major. They are, we would say they were permanent college students. I couldn't afford to be a permanent college student. My mom wasn't allowed anyway. But why?
Ma'am, I made a bad choice. I don't want to sit here and give you any kind of excuse on why I evaded the police. It was just a bad choice I made, Your Honor. And I plan on doing better and finishing my college and starting up a trucking business. But I don't want to sit here and give you the run around or none of that, Your Honor. But
I appreciate that because, it's almost 5 o'clock. I'm here to sit and listen to the runaround if people want to give me the runaround, but I appreciate you not giving me the runaround.
Yes, ma'am.
So are you employed now?
No, ma'am, I'm not employed. I actually got off of the truck with the sum of about $55,000. And I was in CPS when I was younger, so my college is paid for it. So all of the tuition and fees, I get that back for myself. So I haven't worked since I got off the truck.
Okay. So who do you live with? How are you surviving?
I live alone. It's from funds I have from when I was in the trucking business for 4.5 to 5 years is around that amount of time. And then as well as my college funds.
All right. So here's what I'm going to tell you. The money that you have, if you keep, in the words of my grandmother, nibbling off of it, you're going to look up and your savings and whatever money you have is going to be zero.
Yes, ma'am.
So you're going to have to get employment, and I require people who are on probation, if I place them on probation, to obtain employment. Do you understand?
Yes, ma'am.
Okay. This is what the court is going to do. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. There's a $1,500 fine, time, and money to run concurrent. There's to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be 200 hours of community service restitution. You are either going to obtain your college degree or, follow up on your CDL license. If you do those two things, then the court will deem the community service hours satisfied. Take in consideration 2024 PF 10121. And I believe that's also JN 24168. There's to be field visits one time per month for 4 months. Do you have any children?
No, ma'am.
Okay, that is so good. Thank you. You're not ready yet. Probation, is there anything else? Oh, the defensive driving course. Probation, is there anything else he needs? Oh, probated. Sorry. No. If he obtains his college education, or if you get your CDL license, the community service hours will be deemed satisfied. Thank you. Do you need anything else from the court?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. That pounding you felt in your chest, that was a pounding because you didn't know if you were going to be going to prison or not, right?
Yes, ma'am.
Everything you did to come in here to give me something to potentially place you on probation, you need to keep doing that. Because from here on out, everything you do, you're potentially looking at 8 years in the prison, so it can still happen. You understand?
Yes, ma'am.
Who's here on Jalen Collins?
I am your
All right, Mr. Collins, come on up. All right, what is happening with Collins?
Well, Your Honor, we've conferred and he has a motion to revoke. He has a new indicted case. He has some cases out of County Court 4, and he has an at-large case. I've conferred with my client. I've discussed with the prosecutor and with my client about potential resolution for this. He wants to talk to you, and I do not recommend that, but that's my client's wishes at this point, and so we're here.
Right. So, Mr. Collins, before you speak with me.
Yes, ma'am.
All right. So you have an attorney here.
Yes, ma'am.
She went to law school.
He did.
She has a license. And I can tell you that none of us who went to law school spent over $100,000 for law school and did not know what we were doing.
Yes, ma'am.
So it's sort of like if I don't know why people sometimes think attorneys' jobs are not real for some reason. And I can say that because I've been a defense attorney and a prosecutor.
No.
And it is similar to if you go to see a doctor and you have a heart problem and you want heart surgery, you don't tell that doctor, hey, wait a minute, let me just tell you how I think this operation should go. You just let them do it. Once they tell you, this is why you need heart surgery, this is how we're going to do it. You don't tell that person, well, I really think you should use this type of scalpel, and I really think you should use this laser, and I really think this is the direction you should go. So you understand what I'm saying? If your attorney does not want you or recommend you speaking to me, there's probably a good reason for that. And I'm sure she may have told you that. Knowing that, if you still wish to speak to me, you may speak to me.
Man, I would.
Yes.
I would like to speak to you because I know that my attorney has gone to law school just like you have.
No. No, just go. Come.
I'm sorry. It's you're very, I'm very nervous.
Do not be
but
nervous.
I'd rather fight for my life because even though my attorney went to law school, she has not had my discovery today. I've asked to see it, and
All right, let me stop you right
so
there.
I'm
Just 1 second. So with regards to discovery, your attorney has just told me that there are some new cases, right?
yeah, but I have an indictment.
No. I know you may have the indictment, but this is what people don't understand. And let me explain the process to you a little bit. And this is me coming from prosecutor background and defense attorney background. Usually when cases are indicted, your attorney finds out the cases have been indicted. Maybe if the prosecutor has time, they will call them and they will say, hey, we're indicting Mr. Collins' case today. Normally that doesn't happen. What ends up happening is your cases get indicted, and then your defense attorney is aware it's been indicted because they get a message on the system that it's been indicted and they've been appointed. And then they have to make arrangements with the prosecutor to actually see the file. And then once they make arrangements with the prosecutor to see the file, then they can go see you. They don't get, the state doesn't say, oh, here's the entire file, take our entire file over to the jail or take our entire file to the client. What ends up happening is they come to court and you'll be able to see the file if the state actually has their file. So that's how discovery works. I know a lot of people will see things on television.
No, I'm sorry. I just asked her and she said she didn't bring it today. So I was assuming that she had it and she didn't bring it. That's what she told me.
No. This is what ends up happening. When she says not bringing your discovery, and correct me if I'm wrong, Ms. Thorne, what happens is they may have something uploaded on their system, but the state will normally have a file down here. And if the state does not have their file down here, she can't show you discovery. And if you ever have a chance to look at what they receive on the system, it is not the sheets of paper. They have to go in, download it, and get it. And then once they download it, maybe they can show it to you on their computer or something like that. But I will tell you, 9 times out of 10, defense attorneys don't walk around with their computers. So what's your next issue?
Honestly, ma'am, I've been up for 3 years. The day that you agreed on my deal that I testified on, I did not know when you sentenced me to probation. You asked me if I had a child at the time, and I said no. Well, my child was conceived the night before. I have a 2.5-year-old daughter, and I got comfortable. I was walking straight and narrow. I work at Harbor Experts. I had a full-time job. They contracted with CPS Energy. I'm a tree climber, master trade, and I got comfortable. So I'm.
All right, so let me stop you right there.
I want to plea on what's
wait.
true.
Let me just do this. Let me stop you right there. See, this is probably why your attorney doesn't want you speaking. And let me just explain something to you.
I would like to go, ma'am. I would honestly at this point.
No.
I would
Time
like
out.
to
Stop. This is why your attorney probably doesn't want you speaking, because you're about to admit things. It sounds to me, maybe I'm wrong, maybe I'm making assumptions, but you're about to admit to things in the MTR, and you're about to say that this is true, this is true, this is true. And who knows? Maybe the state won't be able to prove those allegations. And your attorney does not want you saying that, because it sounds like to me, you're trying to throw yourself on the mercy of the court, right? Because you're saying, I want to admit to what I did, and what I didn't do, I'm not going to admit to it because I didn't do it. Well, I would always tell my clients when they wanted to throw themselves on the mercy of the court, you got to put something in my hands. It just can't be, please don't sentence me. And so maybe your attorney needs time for that. But what I can tell you is you're not getting out of custody today.
Yeah. Yes.
Okay. So where are we on these new cases?
So one of the cases Ms. Thorne does not have discovery on because it is at large, but I can provide the discovery to her today. It's not alleged in the MTR, but it's going, it has been considered in when making an offer. I'll just say that for the board. Other than that, I've tendered an offer that resolves all of his MTRs or his pending case. The last I spoke with, he doesn't seem inclined to take that, so my assumption is probably needs to be set for a contested.
All right. So, Mr. Collins. So I don't want to know what the offer is, but the state has just informed me that they've tendered an offer to your counsel. And I'm sure your counsel has tendered that offer to you. And maybe you don't like that offer, but I don't want to know what the offer is. I'm not allowed to. And maybe you don't like that offer. That's fine. But if you want to contest it here, we'll go forth with a contested hearing. Or if you want to plead true, you can plead true. And I will make a decision on what to do about this motion to revoke, but that may change the state's offer if you all don't have an agreement. And usually on motions to revoke, I will follow the agreement that the state and the defense have worked out unless there's a good reason for me not to, or if I think it should be something else. Do you understand?
Yes, ma'am.
All right, so now you know that your attorney doesn't have all discovery because there's a case that's at large, and I'm sure she'll explain to you what at large means. She doesn't have access to that yet. The state has said that they will be willing to give her the access to that and the information about that. So that's where we are in your case.
Yes, ma'am.
All right, do you have any questions?
No, ma'am. I would still like to proceed. I just don't, I don't feel comfortable. I don't feel comfortable the way I saw her talking about me too. Yeah, I'd rather leave my life at this time in my own hands. If I can go pro se, if I can just leave it up to you, Ms. Boyd.
Well, I mean, you can still plead true to whatever you want to plead true to and leave it up to me, and your attorney will argue whatever she wants to argue. The state will argue what they want to argue. And if you want to testify before me, you can.
I'd rather do that, man.
Okay. All right. You want to discuss things with your client?
Your Honor, based on things that you've said and I said earlier, I would like to ask for an oral motion to withdraw because I do not feel like we're able to communicate, and I don't think I can adequately represent him. He wishes to proceed pro se, and I need to withdraw, Your Honor. I think there's a conflict.
All right, just have a seat and I'll take this up in a moment.
Right. May I also, I have another report, but I can wait on this.
Okay, just give me a moment.
Thank you.
Mr. Collins, you're requesting that Ms. Thorne withdraw from your case?
Yes, and I would like to proceed pro se.
Listen to my question.
Yes, ma'am. Sorry. Yes, ma'am.
Ms. Thorne?
Yes, Your Honor. I wish to withdraw, Your Honor, based on his comments to the court, his comments to me. I believe it's in the best interest for him to have other counsel, and I do not believe that I can adequately represent him. I believe that there's a conflict, and it's based on what he said on the record here in front of you.
All right. And State, do you have any objection to the defense's oral motion to withdraw?
No.
All right, that will be granted. Thank you, Ms. Thorne.
Thank you, Your Honor.
Have a great rest of your week.
You too. Merry Christmas.
Merry Christmas. We're off the record. You can have a seat. Ms. Thorne,
Yes, Your Honor.
do you have any documents or anything from his case for the attorney who will be appointed?
No, Your Honor, I do not. Other than the motions to revoke, I can.
No, that's fine. They'll get a copy to them then.
Right. No, Your Honor, I do not.
All right, thank you.
Thank you, Judge.